Don't forget to subscribe to my YouTube channel. Hit that like button. Subscribe. Hit that notification bell so that you will be informed when I come on live. What's up, family? Yeah, let's get in. Yeah, let's get in. Everybody come on in to the circle. What's up, family? Yeah, everybody get on into the circle. Yep, so ladies and gentlemen, I wanted to start off by saying peace and love to you, but we have to talk about Kentucky Attorney General Daniel COON Moran. Daniel COON Moran. According to New York Magazine, it's getting harder to deny the likelihood that Kentucky Attorney General Daniel COON Moran lied and lied multiple times when he explained why a grand jury decided not to charge any police officers with the crime of killing Breonna Taylor. Not to, Comeron office presented evidence to the jury, but only criminal charges he announced last week were against Brett Hankinson, the Louisville officer who fired blindly into a Taylor's apartment on March 13 and accidentally sprayed ammo into a neighboring unit. The wanton endangerment charge he faced means that the only officer who will suffer legal consequences of the event surrounding Taylor's death, at least for now, is the only one who didn't have a direct hand in the killing of her. The six officers involved, Jonathan Manley and Miles Cosgrove, shot Taylor 6 times out of more than 30 rounds fired between them. When Daniel Kumaran announced this decision to go public, he characterized it as a just resolution to a universally accepted set of facts. The warrant that the police used to the warrant that the police used to enter the apartment was not served as a no-knock warrant. He claims, rebutting witnesses' accounts that officers had failed to announce their presence before bursting into Taylor's home, causing her boyfriend Kenneth Walker to think that they were being burglarized and shoot one of them in the leg. Walker's bullet was the police justification for opening fire, which killed Taylor, who was unarmed. But failing to announce themselves as a police would undermine the defense. Under Kentucky Castle Doctrine, law enforcement officers are the only home invaders that residents aren't allowed to use deadly force against, but only if they clearly identify themselves as law enforcement. Okay? So we already know it's clear that they didn't basically announce themselves. We knew that they were reckless. We knew that they lied. We knew the detective uh, James, uh, basically who got the warrant, lied to the judge. The judge and it said, "Well, we're gonna leave it up to the FBI because they're investigating." All of it stinks, family, and the reason why all of it stinks because it's a black person. And Daniel Comaran, evidence is now coming out about this new juror that Daniel Comaran never presented murder charges as an option to the grand jury. So Daniel Comaran is basically lying about all of the things of what he claimed to be facts in the case. Daniel Comaran was talking so much about how he was sorry, he met with the family, and decided that we're not going to charge these people for shooting and killing Breonna Taylor. What we're going to do instead is we're going to charge Hankerson, one of the officers, of shooting in the adjacent apartment. And Daniel Comaran, man, you basically is a disgrace. And you should step down, Daniel Comaran. But it also said the question as to why black people still think that we're going to get justice in America. That's what I've been trying to ask the question about. These people is basically telling us that we're not going to get justice. That's the reason why we're out in the streets right now. But Daniel Comeron says that along with these white supremacists that we're being violent. Okay? But it goes on to say that this wasn't the only dubious claim that Comeron expected the public to take as face value. He also said that the grand jury agreed that Taylor's death was justified. While there are 6 possible homicide charges under Kentucky law, he explained, these charges are not applicable to the facts before us because our investigations show and the grand jury agreed that Madeley and Cosgrove were justified in returning deadly force after having been fired upon. But the grand jury may not have actually agreed. On Monday, one of the jurors took the extraordinary step of filing a court motion to make transcripts of grand jury deliberations public and allow its members to speak publicly about that unfold. According to the New York Times, grand jury deliberations are subject to strict secrecy, and that the evidence that they considered usually only become public in courts if there's prosecution. The unnamed juror claimed that Comeron made misrepresentative the jury's case to the public, and that the jurors were never given the option. Listen to this. Never given the option to indict officers Madeley and Cosgrove. If true, this will appear to undermine Comeron's claim that the jury was unanimous that Taylor's death was legally justified. Okay, now let's stop right there. So Comeron did not even present murder charges. This juror is coming out letting us know that. There's another juror coming out to let us know about the lies that Comeron is saying now. But we'll go ahead and read on. It has also cast more doubt on his earlier accounts. Comeron claimed that the officers clearly identified themselves, another lie from Comeron, and therefore were executing a no-knock warrant is supported by the testimony of the officers themselves and one witness, a neighbor of Taylor's. But roughly a dozen other neighbors claimed not to have heard anything until the police battered into Taylor's door. And investigative documents recently obtained by Louisville Courier-Journal show that the AG Long non-police witness originally said that they heard nothing, only changing their story months later when investigators circled